Peace and blessings, everyone. This is Tamara T. Bush coming to you to provide clarity on consumer law as promised. Even though this is a pre-recorded broadcast, I still wanted to be able to give you all the information. I am in Oklahoma City, Oklahoma. I'm on the rooftop of the house of my colleague, my friend, my mentor. I won't say his name because y'all nosy. I'm just playing. But I wanted to, like I said, I wanted to make sure that you all had the information, right? So many amazing things that we've been talking about over the past few weeks, right? And so yesterday we spoke about regulation, and I want to circle back to who holds the liability, right? So what we're going to do is we're going to go through these sections of the FCRA, Fair Credit Reporting Act, the FDCPA, the Fair Debt Collection Practices Act, and Truth in Lending. And I want to basically show you who is holding the liability in these subsections, right? So definitely go ahead and drop your city and state so that I can see where you're tuning in from, because we definitely want to make sure that we can get some groups organized in your area once we go on the road with this information. And yeah, and I'm looking for you all to share your experiences and your understanding of the information that you are learning, because like I said before, want to make sure that you are getting what you need. And so going through this whole process of providing clarity on consumer law, we have to unlearn some information, and sort of like we have to do we have to deprogram to reprogram our minds, because everything that we have been doing up until this point is based off of old, outdated information, right? So we want to be able to bring in the new information. We need to be properly informed of our consumer rights so that we know how to properly assert ourselves in a different situation. So this is virtually our life, right? Virtually our life. So let's go ahead and get into it. I'm going to go ahead and share my screen. Let's get into it. All right. So now, this subsection, and again, let me circle back because you all know that I use Cornell Law, the Legal Information Institute, and please excuse the background noise. I'm on the rooftop, so you're going to be able to hear a lot of background noise, right? But just focus in on, zero in on what it is that I'm saying, right? Okay, so Truth in Lending is 15 USC 1601, and it goes all the way down to 15 USC 1666, 67, somewhere in there. But you could definitely look it up, right? So before I show this information, right, how you can go into the sub chapters of the code to basically look at different topics and information that's being offered. But today we're going to speak specifically about criminal liability for willful and knowing violation, right? And this is 15 USC 1611. 15 USC 1611. And I did cover this on one of my other videos. Okay, so keep that in mind. Now, Truth in Lending, whoever willfully and knowingly gives false or inaccurate information or fails to provide information which he is required to disclose under the provisions of this subchapter or any regulation issued thereunder, uses any chart or table authorized by the Bureau under Section 1606 of this title in such a manner to consistently understate the annual percentage rate, right, determined. Otherwise, who fails to comply with any requirement imposed under this subchapter. Now, what is one of the things that we spoke about in regards to truth in lending? If you all recall, I took you through the billing error dispute process, right? Which is 15 USC 1666, which is also a subchapter of truth in lending. Okay, so think about it like this. When you begin to submit your billing error disputes and the company or the financial institution or the bank does not comply, you have to hold them accountable, but they will comply. Truth in lending, they'll comply. But I'm just saying, if they don't, you have to hold them accountable. And what did I say yesterday? Is not in the fact that you know how to do the administrative process. It is definitely in the enforcement. So you have to know how to go in and enforce the law with these companies that are violating you every single day, right? It is definitely a must. Okay, so let's go back. Let's go back. All right, so we are in criminal liability section. So What is this telling you? This is telling you that it is a criminal offense, that it is a criminal offense to violate any subchapter of truth in lending. Okay. And then there's a civil penalty, right? What does it say? Shall be fined not more than $5,000 or in prison not more than a year or both. Now, you all know that these executives don't want to go to jail. They don't want to go to jail. But the problem is that they get away with it because you, the consumer, do not know how to properly assert yourselves, nor do you know the law, nor do you know how to hold them accountable for those violations, right? So this is something that we have to be in tune with, knowing how to hold them accountable. And so on yesterday's video, this is why I gave you some of the resources for who regulates who, because everything works together towards the common goal. And there's so many different moving parts in terms of enforcing consumer law that we have to know where to go when something happens, right? It's sort of like a diagram. It's like, okay, you start out here. If X happens, you do 1, 2, 3. If Y happens, you do 1, 2, 3, right? So we really have to know who the bosses are, how to hold them accountable, right? And when we do those things, we are actually properly asserting ourselves as a consumer. Now, this particular subsection says whoever willfully and knowingly, right? It says whoever. So whoever can potentially include the consumer, it can include the debt collector, it can include the creditor, it can include the obligor. It says whoever. It does not specifically define who holds the violation of the subsection, right? So this is just reiterating what I spoke about in one of my previous videos when I said that you have to know how to properly define yourself to make sure that you are not holding on to that liability when you're trying to enforce what that company is supposed to do. Right? It says whoever. It doesn't say who. It says whoever. So you have to be careful. You just have to be careful. You have to know who you are, which hat you're wearing in each and every consumer credit transaction that you're taking advantage of. Every single one, every single one. So this particular subsection, again, is 15 USC 1611, and this is the criminal liability for willful and knowing violation. This is the for truth in lending, okay? All right, now let's move on to the FCRA. Civil liability for willful noncompliance. These companies are literally willfully non-compliant every single day, right? The FCRA, this is specifically making reference to your relationships with the consumer reporting agencies. And yesterday I spoke about the fact that there are hundreds of them, probably over 300 consumer reporting agencies that buy and sell and make money off of your information every single day, right? So when they report inaccurate, unverifiable information and you don't hold them accountable, they get away with it. There is a civil liability section for this. So we are virtually leaving money on the table because we do not know how to go after these companies, right? So what does it say? Any person who willfully fails to comply with any requirement imposed under this subchapter with respect to any consumer is liable. Now, what's the definition of a person? The term person means any individual, partnership, or corporation. It doesn't say anything about a consumer being liable under the subsection. So it's very important that you know who the people are that is violating you. So when we say they, you say, oh, they did this to me, they did that to you. So you know who they is, you know who they are. You know who they are. An individual, a partnership, a corporation, a trust, an estate, a cooperative, association, government, or governmental subdivision, or agency, or other entity. You know who they are, okay? A person who willfully fails, willfully means they did it on purpose, they did it intentionally. They know that they're wrong, but they still did it. That is willfully, right? Willfully fails to comply with any requirement, any means all. Any means all. And so when you look at the FCRA as a whole, there's a whole lot of things that they're supposed to do that they're not doing. So that says any, that means all. It doesn't mean or, it means all. So if they have to comply with 1681B, that means that they also have to comply with 1681C, C1, C2, D, E, F, all the way down the line to the end, right? That's what that means. That is what that means. All right. So we have to pay attention to that. All right, so let's go back. All right, civil liability for willful noncompliance. Any person who fails to comply with any requirement imposed under this subchapter with respect to any consumer. Who are you? You are the consumer. Yesterday, I specifically provided you with those resources and pointed out to you that the regulators are referring to you as the consumer. So why do you not refer to yourself as the consumer, right? It means an individual. Now, the term consumer has different meanings depending on the law that you're reading. But for the most part, that's me and you. That's the everyday person, right? The average person is the consumer. Anyone who is trying to make a better life for their family, who is taking advantage of and using financial products and services from all of these different companies out here, where we sign agreements, we engage in commerce every single day. We're the consumer. Any actual damages sustained, okay? Any actual damages. So what did I say before? And I'm just gonna reiterate this again. If you have a derogatory item that is reporting on your credit report that is not supposed to be there, because remember that no consent equals identity theft, right? No consent equals identity theft. We went over the 4-day block and remove. We went over the 4-day block and remove. So I explained to you the reason why you can state that it's identity theft in good faith. Okay, so if you have a collection item or a charge off or something that's reported on your consumer report, and because that item is being reported, you are denied credit, or the amount that you applied for has been reduced due to your quote unquote credit rating. That is considered an actual damage. I'll give you an example. If you go and you apply for a $100,000 loan, they only give you $20,000 because they say that you have a low FICO score or you have derogatory items reporting on your credit report. The difference in the amount that you were approved for compared to what you applied for, that's the actual damage. That is the actual damage. That's why it says actual. Any actual damage sustained by the consumer as a result of the failure or damages of not less than $100 and not more than $1,000. Now, you see this or, and remember, in legal language, or means the right to choose. So that means that you can choose. You're either going to go after them for the $1,000 that you know that they're liable for violating that subsection that they violated, or you're going to go for actual damages. I don't know about you, but I'm going to go for actual damages all the time because you're literally messing with my livelihood, so you owe me money. And I'm going to go for the amount that I was supposed to get approved for in the first place, right? All right. In the case of liability of a natural person for obtaining a consumer report under false pretenses or knowingly without a permissible purpose, actual damages sustained by the consumer as a result of failure or $1,000, whichever is greater. Such amount of punitive damages as the court may allow. And in the case of any successful action to enforce any liability under this section, the cost of the action together with reasonable attorney's fees determined by the court. We leaving money on the table. Civil liability for knowing noncompliance. That means they know and they still do it. Any person who obtains a consumer report from a consumer reporting agency under, okay, you get it. I don't have to read the whole thing, right? You get this, you get this. I need you all to study this because this is your money. This is your bag, as they say. Y'all always talking about getting the bag. So why are you not getting the bag? Like, seriously, you're always talking. I keep hearing this. Oh, we got to get our bag. We got to get, y'all always talking about getting the bag. So why are you not going out and getting the bag? Why are you not studying so that you can get your bag? Hear me. This is important. All right. So again, this is 15 USC 1681N, which is the civil liability section for the FCRA. Listen, let me just take a little segue for a second. Let me take a segue. These laws are actually fun to read. It's like reading a story where you're the main character, right? Because you literally will be telling your story and what happened to you. You are the star of the show. Literally, you are literally the star of the show. And I know that reading is a lost art, but we have to make it fun again. We have to dive into these laws because I promise you, nobody can do this but you. Nobody can do this on your behalf. Nobody should do this on your behalf. And if they try to do it on your behalf, shame on them if they take your money and try to do this on your behalf. Nobody can properly assert themselves. Nobody can assert your rights for you as a consumer. You have to do it yourself. That's why you have to learn this information. Because when you go into arbitration or litigation, that person cannot speak for you on your behalf. You're going to be representing yourself pro se all day long, because remember, attorneys are officers of the court. They work with the judge and they work with the attorney on the other side. Everything that they do is not for your benefit. They are not there to benefit you. They're foreign agents. So nobody's going to be able to properly assert themselves for you but you. Y'all gonna keep hearing me saying this. You have to want this. You have to want this. And you have to be able to take the time out to study. All right, let's move on. I can go on all day, right? Okay, now 15 USC 1692K. This is the liability set. Oh, wait, let me go back for a second. Hold on. There's actually two liability sections of FCRA. So it's going to be 1681N and 1681O. So definitely take the time out to go and read this section as well. Any person who is negligent. Now, you know, negligent is a higher level of fault. Think about it. When somebody is in a car accident, or yeah, that's a good example. Somebody's in a car accident, they can be found negligent if they had a DUI or if they kill someone. You know, you ever heard of negligent homicide? This is an actual higher damage under this particular subsection. So just know that under the FCRA, there's more than one area of liability under which a company can be held liable for being willfully non-compliant. All right. 15 USC 1692K, which is the civil liability section of the Fair Debt Collection Practices Act. And again, I'm on Cornell Law, the Legal Information Institute, right? Okay. Except as otherwise provided by this section, any debt collector. Okay. Now they're being more specific. Notice in this section, they don't say person. They say debt collector. So remember, if you are trying to enforce the FDCPA, the debt collector holds the liability. Any debt collector who fails to comply with any provision of this subchapter with respect to any person is liable. Okay. In the case of any action by any individual, such additional damages as the court may allow, but not exceeding $1,000. That's what it says. All right. So it specifically defines the liable party as the debt collector. All right. So let's go back over here real quick because I want to see something. Show you all something. Correction of billing errors. This is part C. There is, hold on one second. We're going to go into the CFR codes real quick. That's not it. FPB.gov. FPB.gov. Yes, go to the website. Yes, I know. It's a good website. You can let me go. Okay. You can definitely let me go. Okay, so let's see. I'll just do a search for TILA, which is truth in lending. Oh, exactly what's going to come up, but I think it is CFR. The CFR 1002. It's one of these. Okay, there it is. The Equal Credit Opportunity Act. Wait, is this the one? Hold on, hold on. Hold on. Now, there is a CFR code. The CFRs are the Code of Federal Regulation, right? The CFRs outline the procedural obligation for these companies, and it gives you more direction in terms of enforcement, right? But I want to show you something specific. I just have to find it. This is going to be CFR. Let's do it. Okay, it's Reg Z. So now you go back over here, go back to the CFPB.gov, Reg E at ZZ, Reg Z. There we go, Truth and Lending. That's what I was looking for. This is what I was looking for. I was looking for CFR codes. This is some of the due diligence that you will have to do. It's just the way it is. You will have to actually get in here and start looking up some of these terms. I can't, there's no way for me to download my mind into your mind. So it's going to be some research required on your part. You will never be able to get away from researching and studying the law ever. It just doesn't work that way. So just get comfortable now, because I'm not going to have y'all in my inbox asking me all these questions about no templates and none of that stuff, because templates do not work when you are doing this. You literally have to tell your own story. I can give you guidance, but I cannot give you anything that is going to hurt you. These companies are saving these templates, they're saving this information, and they know when a group of people has gotten a hold of some templates. So we're not going to do that. We are not going to do that. All right, so this is actually, so Cornell Law actually has the CFR codes as well, right? You're either going to go to the CFPB website or you're going to go to Cornell Law, okay? And I'm trying to find, there's a section that I'm looking for. I can't find it. I may have to give it to you all in the next video. I may have to give it to you all in the next video. It's in here though. It's definitely in here. Let's see, view current regulation. The authority, purpose. Let me see if we can get down to the liability section, civil liability section for Truth and Lending. I know it's on one of these little, one of these ones that I open up, right? Statement of credit, advertising. You see how you have to really go in here and play with it? You have to go in and play with it. Let's see. Y'all, listen, that billing error, y'all got to get into this one right here. CFR 1026.13 billing error resolution. Everybody wants to know how to do billing error disputes. I'm giving it to you right here. This is literally the steps. It gives you the definitions. It gives you how to submit your notice. This is virtually everything that you need to know. Literally everything that you need to know. Right? And under the billing error dispute process, the creditor is liable. That's what I was trying to find. It's the creditor. And so this is how, this is why I was saying before that you have to know who you are in every transaction. Every single consumer credit transaction, you cannot state that you are the original creditor. That is not going to fly. It's not going to work, because you're literally opening yourself up to hold the liability. Cannot do that. So you have to be smart in how you assign a title to yourself when you're going through your administrative process, right? All right. So I say all of that to say that get into the liability sections of these laws, because it is going to benefit you. Do not leave money on the table. Get your remedy. But in order to get your remedy, you are going to have to study Treat your life like a business. Get your office set up at home. Get you a computer. If you don't have a laptop computer, go ahead and invest in one. You're going to need a printer. You're going to need plenty of envelopes, legal paper, right? Black pen, blue pen, red pen. Get yourself set up like an office, because in order for you to do this with all of your bills, in order for you to go after these companies, after these open-ended accounts, open-ended means it goes on forever. Every single bill is a security, people. Every bill that you get in the mail every single month, it's a security of which you're supposed to receive the value of that security back every single month. I cannot make this stuff up. This stuff is stated in the UCCs and in the CFR codes, but I ain't gonna get into it here. I'm just telling you. Anyway, so again, and this is Tamara T. Bush, providing consumer clarity today for all of the liability sections of the Truth in Lending, the Fair Credit Reporting Act, and the FDCPA. Let's get to studying. Y'all make it a great day. Peace and blessings, and I will see you in the next video.